Madam Chair, Richard Kirby on behalf of Marion O'Brien of Cumberland, Rhode Island. The objection's been filed against Mr. Della Fuente pursuant to the Rhode Island statute that would require in a primary that a voter at the date of declaration.
Mr. Kirby, just for 1 second, I want to make sure do we have a record? Does the board have these documents?
You have
The objection.
Objection and motion to disqualify. I don't know if there are any other documents, but that includes his declaration, Mr. Della Fuente's declaration.
So we should mark these. Yes, I think I have a copy here as well as the original. So the Exhibit A will be the objection and motion to disqualify Della Fuente as a Republican candidate for the United States Senate. Along with the attached Exhibit A, which is the actual declaration of candidacy of the same individual. I don't know if there are any other, I believe that's the entire record in this case.
And there's no one else that wants to be heard on this matter? No.
I have not seen anything else. This is all I've received. So I do not know if anything else has been filed. I don't think anything else has been filed from Mr. Della Fuente.
So we should hear from
Yeah.
the gentleman.
Yes.
Mr. Kirby.
Thank you, Madam Chair. As the board is well aware, the Rhode Island statute requires that under a primary, candidate on the date of declaration must be a qualified voter. At the date that Mr. Della Fuente pulled and filed his declaration of candidacy, he is a resident of California and not a qualified voter in the state of Rhode Island. I'm also aware, I'm not sure if the board is aware that Mr. Della Fuente's declared candidacy in a number of other jurisdictions throughout the country to run for office. I represent Marion O'Brien, also the campaign manager for Robert Flanders, the Republican nominee for the Rhode Island for this U.S. Senate position. We would ask that he be removed to mockery to the system, to just file, pay people to get papers, and then pay people to go out and get 1,000 signatures and be on the ballot, particularly when the Rhode Island statute in a primary requires that you be a voter on the day you make your declaration. If Mr. Della Fuente was serious and wanted to be a candidate for the United States Senate under any constitutional provision, he could have declared himself as an independent. But he opted to utilize the primary process here in the state of Rhode Island, selecting to be a Republican, and he ought to adhere to the Rhode Island statute, which requires that he be a qualified voter on the day he made his declaration.
And Mr. Kirby,
he was not.
with respect to the Constitution, which you just referenced, how do you square the two? The statutory framework clearly sets forth requirements on residency, but we have the provision from Article 1, Section 3 that speaks to the qualifications and eligibility for the United States Senate.
Under the United States Constitution. However, you have to take a look at the fact that this is a primary. The United States Constitution does not identify political parties. However, the state of Rhode Island, in enacting the Chapter 17 of the Rhode Island General Laws, identified a process for primaries. Mr. Della Fuente opted to enter the primary process, subjecting himself to your jurisdiction, to the Board of Elections. That means he has to comply with the statutory provisions, never mind any other rules and regulations promulgated by this board.
But we must also comply with the United States Constitution.
You're not preventing Mr. Della Fuente from being a candidate for the United States Senate if he had declared himself as an independent.
Do you have any case law that addresses this issue that you want to share with the board?
Not at this time, but I will say, I mean, I'm not saying that you are preventing him, it's just that he opted for the primary process. He opted to run as a party that's been identified by Rhode Island state statute that would require that he fulfill all of those requirements, which would be to be a qualified voter on the day he declared to be a Republican candidate. It's entirely different from being an independent candidate, where he could have filed, said, I'm an independent candidate and I want to get 1,000 signatures and be on the ballot, and then comply with the rest of Article 1, which was talking about being a resident on the day that you are sworn in to take the oath of that office.
If I can give you my guidance as best as I can at this point.
Does anyone have any questions of this gentleman before we proceed?
So just to clarify your argument, you're saying that he could run as an independent even though he's not a resident of Rhode Island because the Constitution says, U.S. Constitution, says you just have to be a resident on the day of the election.
Correct.
But that if he wants to participate in the party primary process, then he has to follow the rules for being eligible for the primary.
Correct.
Time. Okay.
There's
So
the United States.
that's an interesting, that's not exactly what I was initially hearing, but I think that's...
The United States Constitution never even identified political parties, as Judge Erickson, I'm sure you're well aware, but he opted to utilize the primary process in a political party. He opted to be a Republican, then you comply with what the rules are. Pretty simple.
I think Mr. Kirby's argument is reasonable. I think that there is certainly merit to it. There are a number of statutes that come into play here under Chapter 14 of Title 17, including Section 1, Section 1.2, Section 2, and a number of others that speak to the residency requirements in this process, particularly when we're speaking about a party endorsement. The reality, though, is that we have to also factor in the clear language of Article 1, which reads that no person shall be a senator who shall not have attained to the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. You must be an inhabitant, and then it specifies the time when you must be, which is inconsistent with the entire statutory framework that we have. The United States Supreme Court has dealt with this issue in different circumstances. The case that I think is of most direction to this board is United States Term Limits, Inc. versus Thornton, which is a 1995 United States Supreme Court decision, 514 U.S. 779. That case prohibited the state of Arkansas from imposing any additional qualifications for the office, including term limits. And in doing so, the court reviewed back at the history of case law on issues of residency and the interplay between state requirements and the constitutional mandate. And at this time, Justice Stevens said back in 1995, "We find it appropriate to take note of the striking unanimity among the courts that have addressed this issue. None of the overwhelming array of briefs submitted by the parties and amici briefs has called to our attention even a single case in which a state court or federal court has approved of a state's addition of qualifications for a member of Congress. To the contrary, an impressive number of courts have determined that states lack the authority to add qualifications." They cite probably 20 cases in different areas. One set of cases starts from 1958 regarding residency requirements, including Hellman versus Collier, a Maryland Supreme Court decision from 1958, and then several federal court decisions that followed that in the 1960s. I could find nothing that would support the reasonable position and the statutory framework that we have. A case that I think is also very instructive is Texas Democratic Party versus Benkiser, which is found at 459 F. 3rd, 585, Fifth Circuit decision from 2006. And in that case, the Republican Party was attempting to keep off of the ballot then Representative Del Rey of its own delay of its own party.
This is the Texas case.
This is the Texas case. And it found that Mr. DeLay actually resided in Virginia at the time that he was seeking his nomination for the Republican Party. And the Fifth Circuit dismissed that, saying that the issue of residency, whether he's in Virginia because he at that point was in Congress or was a resident of Texas, was of no moment. The analysis needs to be on the day that he is actually elected to that office, consistent with the language that I cited at the beginning from Article 1. So it seems to me that based on all of the case law that's been developed, none of which is from this state, but there is a body of cases that instruct us to give a wide berth to adding additional qualifications for the offices of Congress that are not specified within Article 1.
Madam Chair?
Does anyone have any other questions on legal counsel or any clarifications?
Just to put the same issue on the same level, your position, particularly based upon the delay case, is that the party cannot, as part of its primary process, create greater limitations on who can run.
With respect to residency. With respect to residency, because the Constitution speaks to it, the nomination process, having the required number of signatures, for example, it's silent. So you can in a rational way, you can regulate the election process, particularly when you want to see someone who represents your own community. I mean, what Mr. Kirby is saying, it's a reasonable position, but I could not find any case law that supported that.
Mr. Kirby?
Madam Chair, through the chair, I'd like to inquire from legal counsel a few legal points. One, I agree that the statute as designed encourages residents of the state, particularly of the state of Rhode Island, to be the true candidate to run for office. Requires it. Well, there's another reason why the statute also requires 1,000 signatures. And if someone didn't get 1,000 signatures, they don't get on the ballot. I mean, that,
completely agree.
So
It's a reasonable regulation of the election process. And that's
and
what
the reasonable regulation in 1714-2 is a qualified voter. Mr. De La Fuente is not a qualified voter, not a resident. Case law is legion on what residency becomes.
Mr. Kirby, you can't ignore the constitutional language. I mean, I'm aware of the statutory requirement. We have to read it. We have to harmonize both the United States Constitution as well as the state requirements.
He could have had a symphony, if you want harmony, if he had decided to run as an independent. But he chose to run as a Republican in a primary. That primary process is dictated by statute. The Constitution doesn't override the statute in this particular case. Normally, and I agree, statute does not override constitutional authority. But this is not a constitutional issue yet. In order to be a Republican candidate, you have to follow the statute, and he didn't do it. Game over. If he wanted to run as an independent, that's a different story. He wasn't a qualified voter on the day he opted to run and a primary.
Okay. Does anyone have any questions? Dr. Amos?
Then the issue is the primary. Based on what you read, you was talking about an election, right? In terms of election, but a primary, is it any different?
The closest case, and I found nothing inconsistent with it, is from the Fifth Circuit, which I addressed, and that's just over 10 years old. That dealt with House Speaker delay, and that was in the context of a primary, where the party itself, his own party, said that he cannot be on the ticket in Texas because he resides in Virginia, and the court said that very well may be, but he needs to reside in Texas on the day of the election. So it rejected that requirement.
there was a statutory difference in that case as to being a resident on the day of the election. Our statute, in fact, states, does it say that?
Hold on. That requirement of being on the day of election is the United States Constitution. That's why we can't move from it. That's part of the Constitution.
There's a distinction. Being in the primary on the day that you declare that you want to be a Republican, he could have picked the Democrat angle, he could have picked the Republican, or he could have picked an independent. He decided to enter a primary, and the primary requires that on the day that you declare that you be a qualified voter. This is not an anti-carpet bagging thing, it's just makes sense. Just like requiring someone to have 1,000 signatures for governor, United States Senate, is you don't want any Tom, Dick, and Harry out there trying, you'd have a ballot that would go on for pages. You require 500 signatures for the United States Congress. Those are difficult things to get, and there's a reason why, so that you can have a control over the process. You control the primary process, the statute controls. I believe that you're not depriving anyone of a constitutional right. If Mr. De La Fuente had opted to run as not in a primary, but he wanted to be an independent candidate, he could have gotten 1,000 signatures, he could go that route. But he opted to run in a primary, which is completely different.
You've made the point, thank you.
Thank you.
What is the pleasure of the board?
If I may.
Yes, Judge Erickson.
I understand counsel's argument here very clearly, and I also have some sympathy for it. However, because as we know, if we think about the larger picture, primaries are not constitutionally required. Parties don't have to use primaries. They could use caucuses, they could use committees, they could use any mechanism they want. So they're free to make a determination as to how they identify the candidate of the party for a particular office. However, they're not free, and I think there's a lot of case law on this, and this is an ancillary issue to what we're talking about, but there's a lot of case law that says the parties cannot, in establishing their primary process, impose restrictions on who may be a candidate of the party that violate constitutional standards. So the party couldn't, for example, prevent any woman from running, or anybody of Swedish descent from running. There are all sorts. The party can't do that because the party, although it has the option of determining how it makes its candidates certified, they can do that conceptually. If they're going to do it in the primary, then they have to, under any circumstances, they have to follow the constitutional requirement. The constitutional requirement here is that you only have to be a resident of the state on the day of the election. And given that fact, I think the party has to follow the constitutional requirements and not their own requirements for who's eligible. And so I would move to sustain the Secretary of State's decision in this case that Mr. De La Fuente is a valid candidate. I think that's where we're at, right? The Secretary of State.
I think the motion would be to, along the lines that you just said, it would be to deny the objection. Deny the objection.
Deny the objection.
To disqualify Mr. De La Fuente on the basis of residency only.
Right.
Is that a motion?
Yes.
Do we have a second to Judge
Second
Erickson?
it. Second it.
Moved and seconded to deny the objection. Any discussion? All in favor signify by saying aye.
Aye.
Those opposed?